Assalamualaikum. Today we group 5 would like to present about a case bill of lading. So this is our group member. Then shall I start with the case that we choose is the Borealis EB versus Stargas Limited and others, also known as the Birch of Caesar case found in 1998. Moving on to the next slide is what is bill of lading. So a bill of lading is a document provided by a carrier when goods are shipped, acknowledging the receipt of goods. It serves as both a receipt and also in some cases as a title of the document. This means that it can be used as a proof of ownership, allowing the holder to claim ownership of the good upon the delivery. So next slide is the summary of the case. But in short, the Birch of Caesar case, there was a deal between a ship owner and also someone who need transport for coal. They agreed on the type of coal to be shipped from Venezuela to the Taiwan, and this was detailed in their contract and the shipping documents. But during the journey, the ship owners swapped the good quality coal for a lower grade one without telling the other party. When this was found, the court decided the ship owner broke the contract and shipping terms. They had to pay the other party for any losses, including the price difference between the coal grades and any extra costs caused by the swap. For slide 6, who is the caterer? So basically, a caterer is like a renter of a ship, either for a specific trip or a set period. They pay the ship owner for the use of the vessel and take on duties and risks associated with its operation during the rental period. So essentially, they're the ones who book the ship for their own use. They paying for its services and ensuring it meets their needs. That's all from me. I will pass to the next person.
Hi, madam. My name is Noraina Balkis. And who is a ship owner? A ship owner is the person or company that owns a ship. They are responsible for the ship, on how it's operated and what happens on it. Sometimes the person using the ship, like a company renting it, might not be the same as the owner. Next slides. Is it okay? Next slides. Okay, next slides. For the issues, whether the ship owner's decisions to substitute the grade of coal without informing the charterer constitutes a breach of contract under the terms of outlined in the charter party agreement and the bill of lading. Uh, who has okay. For the issue whether the ship owner's decision to substitute the grade of coal without informing the charterer constitutes a breach of contract under the terms outlined in the charter party agreement and the bill of lading. Next. Who has the right to terminate the contract and why? In this case, the party that likely has the right to terminate the contract would be the caterer. This is because the ship owner breached the contract by substituting the cargo without informing the caterer, which violates the terms of the agreement. As a result of this breach, the caterer may have the right to terminate the contract and seek remedies for any losses incurred. Next. Next. Is there any valid contract between both parties? Yes, there is a valid contract between both parties in the Birch Caesar case. The contractual agreement between the ship owner and the caterer for the transportation of coal from Venezuela to Taiwan was based on a charter party contract. That's all from me. I will pass for the next presenter.
Hello and Assalamualaikum madam. My name is Noasha and today I will continue about my part, which is the rules. So for the first rule is the breach of contract, which occurs when the other party fails to fulfill its obligation under the terms of the contract. For example, in the case of Birch Seesaw case, the ship owner's choice to substitute the grade of the coal without alerting the carterer is a breach of contract under the rules of the Carterer Party Agreement and the Bill of Lading. Next is the Carterer Party Agreement, which is a legally enforceable contract between the ship owner and the carterer that specify the terms of the cargo. The ship owner and the carterer precisely state the quality and the specification of the coal to be transported by changing the lower grade coal to the higher grade coal without contacting the carterer. Next is the custom rules for the both exporting and importing countries may have a paperwork and declaration requirements that relate to the custom clearance of the product. Failure to provide adequate notice of the level or tier of the product may be a violation of these guidelines. Lastly is a bill of lading which is produced by the ship owner appropriately reflect the provision of the Carterer Party Agreement and specify the cargo as high-grade coal. Any variation from this prescription, such as changing the grade of coal in transportation, would be believed a breach of provision contained in the bill of lading. So for the next is the regulation in section 3(2) of the COGSA states that the carrier shall properly and carefully load, handle, stow, carry, keep, care for, and discharge of the goods that been carried. So according to the case of Evia Luck 2009 EWHC 3124 com, changing a grade of cargo without adequate warning can be considered a breach of contract. So next, for the section 10, COGSA covers the issue of bill of lading, carrier's responsibility to correctly record the information that the goods have been carried. Any deviation from this description without proper notification, caterer could be interpreted as a violation of Section 10 and contribute a finding of breach of contract under COGSA. Section 4 COGSA specifies the exception restriction to the carrier's obligation, such as cases in the cargo loss or damage is caused by the event outside the carrier's control or the item's inherent fault. It may not be fall under those limitations and may be considered a breach of contract under the COGSA. That's all from my part. We pass to the next presenter.
Assalamualaikum, my name is Alfiza Kamarinas and I will continue presenting the application. First is the breach of contract. So the first point is to demonstrate the presence of a legally binding agreement. So the charterer must demonstrate mutual consent, consideration, and an intention to create legal relations. Next is identifying specific requirements. The charterer must provide substantial evidence such as witness accounts, bills, or correspondence to support the ship owner's claim of a violation of a contract. According to the Contract Act 1950, next slide. Compensation for failure to discharge obligation resembling those created by contract, Section 74, Clause 3, when an obligation resembling those created by contract has been incurred and has not been discharged, any person injured by the failure to discharge it is entitled to receive the same compensation from the party in default as if the person had contracted to discharge it and had broken his contract. So moving on to the second application, which is the Charter Party Agreement, it is necessary to establish the existence and validity of the Charter Party Agreement. This involves verifying that a consensual agreement was had between the ship owner and the charterer. Important consideration includes the vessel specifications, the duration of the charter, the freight rates, and any other terms and conditions that may have been agreed upon. Furthermore, it is crucial to consider any applicable laws in the shipping industry. These elements may affect how a contract is interpreted and how each party's rights and obligations are determined. Next slide. Moving on to the next application for the third rule, which is customs regulations. Customs regulations are essential to international commerce because they guarantee compliance with several legal obligations that protect economic interests, public health, and national security while promoting and the free movement of commodities. It is crucial to pay attention to customs documentation and reporting regulation in order to guarantee seamless and legal international commercial transactions. This include accurately filling up bills of lading, invoices, customs declarations, and other pertinent paperwork. Moreover, customs valuation is an essential component of custom laws, particularly when dealing with international transactions. Determining the import products customs value is crucial for calculating the relevant duties and taxes. Inconsistency and misstatements is in the claim value of product might lead to customs audits, inquiries, and possible accusations of fraud or evasion. That is all from me. Now I'll pass to the next presenter. Thank you.
Assalamualaikum. Now moving on to application 4, I'm gonna focus on the terms of bill of lading. So as we know, when it comes to application, we have to connect the issue or situation in the case with the law that we can apply. So here, the situation is the ship owner changed the grade level of coal without the charterer's consent. Now, the connection here is usually the terms of bill of lading likely specify the type and quality of goods to be shipped. So if the ship owner changed the grade level of coal without authorization, it may breach these terms. The bill of lading from Brolias AB, which is the ship owner, to Stargas Ltd, which is the charterer, and the others would detail on how the goods are transported on the ship Bridge Caesar. The bill of lading, next slide. The bill of lading would consist elements like description of goods, place of loading and destination, condition of goods, responsibility of carrier, delivery terms, and lastly, insurance and liability. The bill of lading would outline details about the goods being transported like coal, including information on quantity, weight, quality, or grade. So in this case, what does it mean? If the bill of lading doesn't match the actual delivery or condition of the goods when they reach the destination, it could be a breach of contract. Borealis AB changed the grade level of coal without the charterer's consent. It could potentially breach the terms specified in the bill of lading. Let's say Boreas AB switched the quality of coal. They were shipping without asking the charterer first. That move might break the rules laid out in the bill of lading. It's like if you order a pizza with pepperoni, but the delivery guy show up with pineapple instead without checking with you first. So now in this case, the bill of lading describes the cargo's grade of coal, which was agreed upon in the contract. The ship owner's decision to substitute the agreed upon the grade of coal with a lower quality grade without informing the charterer would likely be considered a deviation from the terms specified in the bill of lading and the contract. The ship owner probably broke the contract by not following the terms in the bill of lading and the agreement. This could mean they have to deal with legal consequences and responsibilities. The consequences of the ship owner's decision to substitute the grade of coal without consent could have significant financial, legal, and reputation implication for both parties involved in the contract. If we have to find one case that is also related with the same issue, then we have the Leonidas D. So basically in this case, the ship owner substitute the type of cargo without informing the charterer, resulting a dispute over whether the ship owner had a legal authority to make such substitution without the consent. The court ruled in favor of the charterer, holding the ship owner liable for breach of contract. So that's all for me. I will pass to next presenter.
So in conclusion, yes, the ship owner decision to replace the agreed upon grade of coal without informing the caterer goes against the term they both agreed to in the contract and shipping document. So By doing that, the ship owner failed to fulfill their obligation as outlined in this agreement. This breach of contract puts the ship owner in a position of liability, meaning they are responsible for compensating the charterer for any losses incurred as a result of this breach. That's all from us. Thank you.